I knew something was wrong the moment I saw Patricia Henderson standing on my front porch with that clipboard clutched to her chest like a shield, and that tight-lipped smile that could freeze boiling water. It was a Tuesday morning in late March 2025, and I had just finished my first cup of coffee when the doorbell rang. My name is Gregory Thompson, and I had been living in the Meadowbrook community in Scottsdale, Arizona for about 3 years. The neighborhood was nice enough, with palm trees lining the streets and well-maintained desert landscaping that gave the place a polished look. The houses were all similar adobe-style constructions with tile roofs, painted in various shades of tan and cream that the HOA had approved years before I moved in. Patricia was the HOA president, a woman in her mid-50s with short blonde hair that she kept in that particular suburban mom style that required weekly salon visits. She wore expensive athleisure where even though I had never seen her exercise, and she drove a white BMW SUV that she parked slightly crooked in her driveway every single day. "Good morning, Gregory," she said, her voice dripping with false cheerfulness. "Do you have a moment to discuss some important community matters?" I should have closed the door right then. Instead, I made the mistake of being polite. "Sure, what's going on?" She thrust a packet of papers at me, her manicured nails tapping against the plastic cover. The HOA board has implemented a new policy regarding home repairs and improvements. Effective immediately, all homeowners must use contractors from our approved vendor list for any work that requires a permit or affects the exterior of the property. I flipped through the packet, scanning the dense paragraphs of text. There had to be at least 20 pages of new rules and regulations, along with a list of maybe a dozen contractors covering everything from roofing to painting to landscaping. "This is the first I am hearing about this," I said, looking up at her. "When was this voted on?" "The board approved it last week at our meeting. The minutes will be posted online within 30 days as required by our bylaws." "But homeowners did not get to vote on this." Her smile tightened. "The board has the authority to implement policies that protect property values and maintain community standards. This is about ensuring quality work and preventing the kind of problems we have seen in the past." I thought back over the past 3 years. I could not recall any major contractor disasters in our neighborhood. Old Mr. Chen down the street had his roof replaced the previous summer, and it looked fine. The Johnsons had repainted their house, and nobody complained. This felt like a solution in search of a problem. "What if I already have a contractor I trust?" I asked. "Then you can recommend them to the board for approval. We will review their licensing, insurance, and references. If they meet our standards, we will add them to the list. And if they do not make the list, then you will need to choose from the approved vendors." She said it like it was the most reasonable thing in the world. I felt my jaw tighten. "Patricia, I don't think you can actually enforce this. Homeowners have the right to hire whoever they want for work on their own property." Her eyes went cold, and that fake smile disappeared entirely. "Read the packet, Gregory. Failure to comply with HOA policies can result in fines of up to $500 per day, plus legal action to force compliance. I suggest you take this seriously." She turned and walked back to her BMW, her athletic shoes squeaking slightly on my concrete walkway. I stood there holding the packet, feeling my blood pressure rise with each passing second. The thing was, I actually needed to hire a contractor. My air conditioning unit was 12 years old and making sounds like a dying animal every time it kicked on. With the Arizona summer approaching, I needed to replace it before May, or I would be living in an oven. I already had 3 quotes from different HVAC companies, and I was planning to go with a local business run by a guy named Dave Martinez, who had been recommended by my coworker. His price was fair, his reviews were stellar, and he could start work in 2 weeks. I went back inside and actually read through the entire packet. The more I read, the angrier I got. The policy claimed that approved contractors had been thoroughly vetted and would provide guaranteed quality service to protect the community. But there was no information about what the vetting process entailed, no criteria listed for approval, and no appeals process if a contractor was denied. The list of approved contractors was interesting too. I recognized a few names, including one roofing company that had been the subject of multiple complaints on the local community forums for shoddy work and inflated prices. Another approved contractor was a landscaping company owned by Patricia's brother-in-law. I knew this because Patricia had mentioned it at a neighborhood barbecue the previous summer, bragging about how well his business was doing. This whole thing smelled like corruption. I called my wife, Emma, who was at work. She was a lawyer, though her specialty was intellectual property, not real estate law. Still, she knew more about legal issues than I did. "They cannot do that," she said immediately when I explained the situation. "HOAs have authority over certain things, but they cannot force you to use specific contractors unless it is explicitly written into the CC and Articles that you agreed to when you bought the house. And even then, it would be legally questionable. Should I just ignore it? No, do not ignore it. That gives them ammunition to claim you are in violation. But do not comply either. Push back. Ask to see the specific legal authority they are relying on. Ask for the CC and Articles provision that grants them this power. Make them prove they have the right to do this." I spent the rest of that afternoon digging through my closing documents to find the HOA's covenants, conditions, and restrictions. It was a 50-page document written in dense legal language that would put an insomniac to sleep. I read through every single page, and nowhere did it mention anything about approved contractor lists or mandatory vendor requirements. The CC and Articles did give the HOA authority to approve or reject exterior changes that would affect the community's appearance. They could reject a paint color that clashed with the neighborhood aesthetic or deny a request to build a second-story addition. But that was about aesthetics and architectural consistency, not about who did the actual work. I drafted an email to the HOA board that evening. I kept it professional but firm, explaining that I had reviewed the CC and Articles and could not find any provision that granted the board authority to mandate specific contractors. I requested that they provide the specific legal basis for this policy, including any relevant clauses from the governing documents. I also mentioned that I would be moving forward with replacing my air conditioning unit using a contractor of my choice, and that I would be happy to provide the board with proof of the contractor's licensing and insurance if they wanted to verify the work would be done properly. I hit send at 7:30 that evening, and by 8:15 my phone rang. It was Patricia. "Gregory, I just read your email and I have to say I am very disappointed." Her voice had that tone that middle-aged women use when they are used to getting their way and someone has just dared to say no. This is exactly the kind of attitude that undermines community cohesion. "Patricia, I am just asking for clarification. Show me where in our governing documents it says you can force homeowners to use specific contractors. The board has broad authority to protect property values and maintain standards. That is clearly stated in Section 8, subsection C." I flipped to that section. I had highlighted it earlier. That section says the board can approve or reject proposed exterior modifications. It does not say anything about contractors. The contractor you use is part of how the modification is executed. Quality control is essential. But that is not what the section says. You are interpreting it in a way that goes far beyond the actual language. Her voice went up half an octave. Are you calling me a liar? I am saying your interpretation is not supported by the document. There is a difference. We will see what our attorney has to say about that. Expect a formal violation notice if you proceed with an unapproved contractor. She hung up before I could respond. Emma got home around 9, and I filled her in on the phone call. She shook her head while eating leftover pasta from the fridge. She is bluffing, Emma said. HOA attorneys cost money, and most boards do not want to rack up legal fees unless they are confident they will win. She is hoping you will just cave. So I should go ahead with Dave Martinez for the AC replacement. Yes. Document everything. Get the contract in writing. Make sure his insurance and licensing information is current. Take pictures before and after the work. If they try to fine you, we will fight it. The next morning, I called Dave and scheduled the AC replacement for the following week. He was professional and thorough, walking me through exactly what the job would entail. He would pull the permits from the city, his team would remove the old unit, install the new one, and handle all the electrical work. The whole job would take about 6 hours, and he guaranteed his work for 5 years. One thing, I said. The HOA is trying to force residents to use approved contractors, and you are not on their list. I am hiring you anyway, but there might be pushback. Dave laughed. Yeah, I have heard about Meadowbrook's HOA. They contacted me last month about getting on their approved list, wanted me to pay a $5,000 fee and give them a kickback on every job I did in the neighborhood. I told them to take a hike. My stomach dropped. They wanted kickbacks. Oh yeah, called it an administrative fee or some garbage, but it was pretty clear what it really was. They are running a racket. This changed everything. If Patricia and the board were collecting money from contractors in exchange for being on the approved list, that was not just overreach. That was fraud, maybe even extortion. Dave, would you be willing to document that conversation? Write down what they asked for when it happened, who you talked to. Sure, I guess. You thinking about making trouble for them. They are making trouble for themselves. I am just planning to defend my rights as a homeowner. After I hung up with Dave, I started making more calls. I contacted every contractor on the approved list, pretending to be a contractor myself who was interested in getting approved. 3 of them were willing to talk to me openly, and all 3 confirmed that they had paid fees ranging from $3,000 to $7,000 to get on the list. One of them, a painting contractor named Steve Bullock, was bitter about it. It is a shakedown, he told me. But what are you going to do? There are 200 houses in that community, and if you are on the approved list, you get steady work. I paid the fee last year and I have already made it back in jobs. Is it right? Hell no, but it is business. I thanked him and hung up, my mind racing. Patricia and whoever else was involved in this scheme were not just overstepping their authority. They were running a criminal enterprise. The question was what to do about it. I could report them to the police, but I was not sure if white-collar crimes like this would get much attention from law enforcement. I could sue the HOA, but lawsuits were expensive and time-consuming. I could go public, maybe contact the local news, but that would probably just make me a target for retaliation. In the end, I decided to do all 3, but strategically. First, I documented everything. I recorded my phone conversations with the contractors. Arizona is a one-party consent state, so this was legal as long as one person in the conversation knew about the recording, which I did. I saved all my emails with Patricia. I took screenshots of the approved contractor list and the policy documents. I created a timeline of events. Second, I reached out to other homeowners in the community to see if anyone else was dealing with this. I posted in our neighborhood Facebook group, keeping my message neutral and just asking if anyone had questions about the new contractor policy. The response was immediate and overwhelming. Dozens of people commented, many of them angry or confused. Several homeowners said they had already been forced to use approved contractors, and the work had been subpar or overpriced. One woman, Susan Reeves, said she had been fined $1,500 for hiring her own roofer after a monsoon storm damaged her tiles, and the approved roofing company had quoted her triple what her contractor charged. "They are bleeding us dry," Susan wrote. "And there is nothing we can do about it." "Actually," I replied, "there might be." I organized a meeting at a local coffee shop for that Saturday morning. I invited everyone who had expressed concerns about the contractor policy, and I was shocked when 32 people showed up. The coffee shop had to push several tables together to accommodate us all. I stood up and addressed the group, my hands shaking slightly from nerves and caffeine. "Thank you all for coming. I know this contractor policy has been causing problems for a lot of us, and I have been doing some research into whether the HOA actually has the legal authority to enforce it. The short answer is they do not. There is nothing in our CC and Articles that grants them this power." A man in his 60s raised his hand. His name was Robert Chen, the same Mr. Chen whose roof I had remembered from the previous summer. "But they are threatening fines. I cannot afford to pay hundreds of dollars a day just because I want to hire my own contractor." "Those fines are not enforceable," I said. "They are based on a policy that has no legal foundation. But here is the bigger issue. I have discovered that the board is collecting money from contractors to get on the approved list, thousands of dollars per contractor. That is fraud, possibly extortion. They are using their position to enrich themselves." The room erupted. People were talking over each other, angry and shocked. Susan stood up, her face red. "Are you serious? They are taking bribes. I have recorded conversations with contractors who confirm it. I have documentation, and I think we need to take action collectively." We spent the next 2 hours discussing options. Someone suggested a recall election to remove the board. Someone else wanted to file a class action lawsuit. A few people wanted to go straight to the police. In the end, we decided on a multi-pronged approach. We would file a formal complaint with the Arizona Attorney General's office, which handles consumer fraud. We would also initiate a recall petition for the board members, which our bylaws allowed if we could get signatures from 20% of the homeowners. And we would each individually refuse to comply with the contractor policy, forcing the HOA to either back down or try to fine all of us at once. "There is strength in numbers," I said. "They can bully one homeowner, but they cannot bully all of us." We created a group chat and a shared online folder for documents. Several people volunteered to help gather signatures for the recall petition. A lawyer in the group, Michael Porter, offered to draft the complaint to the Attorney General's office pro bono. By the time the meeting ended, I felt something I had not felt in days: hope. That hope was tested on Monday morning when I received a certified letter from the HOA's attorney. It was a formal violation notice, stating that I had failed to comply with community policies by hiring an unapproved contractor. I was given 10 days to cancel my contract with Dave Martinez and hire someone from the approved list, or I would be fined $500 per day until I came into compliance. The letter was signed by an attorney named Marcus Webb from a law firm in Phoenix. I looked up the firm online, and found it was a small practice that seemed to specialize in HOA representation. The reviews were not great. Several former clients complained that the firm encouraged HOAs to pursue aggressive legal action even when the cases were weak, running up legal fees that homeowners ultimately had to pay through increased HOA dues. I scanned the letter and sent it to Emma and to Michael Porter. Emma called me during her lunch break. "This is a scare tactic," she said. "They know their position is weak, so they are trying to intimidate you into backing down. Do not cancel with Dave. Go ahead with the work. What if they actually start fining me? Then we fight the fines." Michael and I have been talking, and we think there is a strong case for getting an injunction to stop the HOA from enforcing this policy. But we need to let them take the first aggressive step. If they fine you, that gives us standing to sue. It was nerve-wracking, but I trusted Emma's judgment. Dave and his crew showed up the following Tuesday morning as scheduled. It was a warm day, already pushing 80 degrees by 9 a.m., a preview of the brutal summer to come. Patricia drove by while Dave's crew was hauling the old AC unit out to their truck. She slowed down, staring at my house, and I could see her on her phone, probably calling the HOA attorney or other board members. The work went smoothly. By 3 p.m., I had a brand new air conditioning unit humming quietly outside, pumping cool air through my house. Dave had been professional and thorough, and his crew had cleaned up perfectly. You would not even know they had been there except for the shiny new equipment. "You are all set," Dave said, handing me the final invoice and warranty information. "If you have any issues, just call me." I paid him by check, and he and his crew packed up and left. I went inside to enjoy the cool air, knowing that the next phase of this fight was about to begin. Sure enough, 2 days later I received another certified letter. This one was a notice of fine. $500 per day for 7 days, totaling $3,500, due within 30 days. Failure to pay would result in a lien being placed on my property. I photographed the letter and uploaded it to our group folder. The response from other homeowners was swift and furious. Several people reported getting similar letters for their own contractor violations. The HOA was not just targeting me. They were going after everyone who had pushed back. Michael Porter filed our complaint with the Arizona Attorney General's office that Friday. It was a detailed document outlining the contractor kickback scheme, including recordings and statements from contractors who had been solicited for payments. We also filed a separate complaint with the Arizona Department of Real Estate, which oversees HOAs in the state. At the same time, we launched the recall petition. Arizona law requires HOAs to allow recall elections if enough homeowners sign the petition. We needed 40 signatures out of our 200 homes. Within 1 week, we had 73. The board responded by calling an emergency meeting. According to our bylaws, they had to give at least 2 weeks' notice for any meeting, but they claimed this was a special circumstance that required immediate attention. The meeting was scheduled for a Wednesday evening at the community clubhouse. Every single seat was filled, with people standing along the walls. I had never seen this level of engagement from the community. Usually, HOA meetings attracted maybe 10 people, mostly retirees with nothing better to do. Tonight, there had to be 150 residents packed into a room designed for 80. Patricia sat at the front table with the other 4 board members. Richard Sanders, the vice president, Karen Whitmore, the treasurer, Helen Brooks, the secretary, and Todd Mason, a member at large. They all looked uncomfortable, shifting in their seats and avoiding eye contact with the crowd. Patricia called the meeting to order and immediately tried to take control of the narrative. "Thank you all for coming tonight. I know there has been some confusion and misinformation spreading through the community regarding our approved contractor policy. I want to take this opportunity to clarify the board's position and address your concerns. How about you address the kickbacks? Someone shouted from the back. The room erupted in agreement. Patricia's face went pale, then red. "That is a baseless accusation," she said, her voice shaking. "The board has acted entirely within its authority and in the best interests of the community." I stood up. "Patricia, I have recorded conversations with 3 different contractors who confirm that they paid fees to get on the approved list. That is not a baseless accusation. That is documented fraud. Those recordings are illegal." "No, they are not. Arizona is a one-party consent state. The recordings are completely legal and have been submitted to the Attorney General's office as evidence." The room went silent. Patricia looked at the other board members, panic visible on her face. Richard Sanders leaned forward, trying to salvage the situation. "Even if some contractors paid administrative fees, that is not unusual. There are costs associated with vetting and maintaining an approved vendor list." $5,000 per contractor, I shot back. "What exactly does that money pay for?" "Because I have reviewed the HOA's financial statements, and there is no line item for contractor vetting expenses." Karen Whitmore, the treasurer, looked like she wanted to disappear under the table. She had clearly not expected anyone to actually examine the finances that closely. Michael Porter stood up next. As an attorney, his presence carried weight. "The board's approved contractor policy has no basis in the community's governing documents. The CC and Artiques do not grant the board authority to mandate specific vendors. Furthermore, collecting fees from contractors in exchange for placement on an approved list, and then forcing homeowners to use only those contractors, constitutes a kickback scheme that violates Arizona's consumer fraud statutes. The Attorney General's office is now investigating, and I would strongly advise the board to seek independent legal counsel, separate from the HOA's attorney." Patricia slammed her hand on the table. "This meeting is over. You cannot just end the meeting," Susan Reeves called out. "We have a right to speak." But Patricia was already gathering her papers, and the other board members were following her lead. They practically fled from the clubhouse, leaving a room full of angry homeowners behind. The next morning, the real drama began. A notice was posted on the HOA website announcing that the board was suspending the approved contractor policy, pending further review. There was no admission of wrongdoing, no apology, just a terse paragraph saying the policy would not be enforced while the board consulted with legal counsel. It felt like a victory, but I knew it was not over. The recall petition was still active, and the Attorney General's investigation was ongoing. 2 weeks later, I received a call from an investigator with the Attorney General's office named Jennifer Liu. She wanted to meet with me to discuss my complaint and review the evidence I had gathered. We met at a Starbucks in Phoenix. Jennifer was in her 30s, professional and direct. She had a folder full of documents and a digital recorder. "Mr. Thompson, thank you for bringing this matter to our attention. We have been reviewing the information you provided, and we have also received similar complaints from other homeowners in your community. This appears to be a clear case of consumer fraud. What happens next?" I asked. "We are opening a formal investigation into the Meadowbrook HOA board. We will be subpoenaing financial records, interviewing board members and contractors, and determining the full extent of the scheme. Depending on what we find, there could be civil penalties, restitution to affected homeowners, and potentially criminal charges if we can prove the board members knowingly engaged in fraud." How long does something like this take? It varies. Could be a few months, could be longer. But I want you to know we are taking this seriously. HOA fraud is a growing problem in Arizona, and we are making it a priority. I left the meeting feeling vindicated. This was not just about my air conditioning unit anymore. This was about holding corrupt people accountable and protecting other homeowners from being exploited. The recall election happened in May. By that point, the story had been picked up by local news. A reporter from the Arizona Republic wrote an article about the kickback scheme, and suddenly Meadowbrook HOA was infamous. The story was shared thousands of times on social media, and Patricia Henderson became the face of HOA corruption in Arizona. The recall vote was not even close. All 5 board members were removed, with over 80% of homeowners voting in favor of the recall. A new board was elected, including Michael Porter as president and Susan Reeves as vice president. Their first act was to formally rescind the approved contractor policy and issue a public apology to the community. But the legal consequences were just beginning. In July, the Attorney General's office announced civil charges against Patricia Henderson, Richard Sanders, and Karen Whitmore. They had been the primary architects of the kickback scheme, and they had personally profited from it. According to the investigation, over $70,000 in contractor fees had been collected over 2 years, and most of that money had been funneled to the 3 board members through fake invoicing and reimbursement claims. The AG's office was seeking restitution for affected homeowners, civil penalties of up to $10,000 per violation, and a permanent ban on the 3 defendants serving on any HOA board in Arizona. In September, criminal charges were filed. Patricia Henderson, Richard Sanders, and Karen Whitmore were each charged with fraud, theft, and exploitation of a homeowners association. The charges carried potential prison sentences of up to 3 years each. I was called as a witness for the prosecution. The trial was scheduled for January 2026, but in December, all 3 defendants accepted plea deals. They pleaded guilty to reduced charges in exchange for avoiding prison time. Instead, they received probation, were ordered to pay full restitution to the homeowners they had defrauded, and were banned from serving on any HOA board ever again. Patricia Henderson, who had once acted like the Queen of Meadowbrook, stood in court looking small and defeated as the judge lectured her about abusing a position of trust. She was ordered to pay $90,000 in restitution and fines, and she had to sell her house to cover the costs. She moved out of the neighborhood in February, and I never saw her again. The new HOA board implemented reforms to prevent anything like this from happening again. Financial statements were now reviewed quarterly by an independent auditor. Board meetings were recorded and posted online. Homeowners were given more direct say in policy decisions through regular votes. And the approved contractor policy was formally removed from all HOA documents, with a note explaining why it had been illegal and harmful. My air conditioning unit still works perfectly, keeping my house cool through the brutal Arizona summers. Every time I hear it kick on, I think about how a simple home repair turned into a months-long fight against corruption. I think about Patricia standing on my porch with that fake smile, so confident in her power, never imagining that homeowners would actually push back. The whole experience taught me something important about communities and power. HOA boards only have the authority we give them. When they overstep, when they abuse their position, it is up to homeowners to stand up and say no. It is not easy and it is not quick, but it is necessary. I still live in Meadowbrook, and the neighborhood is better now than it was before. People are more engaged, more aware of what the board is doing. There is a sense of community ownership that did not exist when Patricia and her cronies were running things like their personal fiefdom. Emma tells me I should write a guide for other homeowners dealing with HOA overreach. Maybe I will someday. For now, I am content knowing that we fought back and won. We proved that homeowners do not have to accept illegal policies just because someone with a clipboard says they do. We proved that documentation and persistence can overcome intimidation and threats. And we proved that sometimes the right contractor for the job is the one you choose yourself, not the one someone else is profiting from. Dave Martinez still does HVAC work in Scottsdale. His business is thriving, and he never paid a dime to get on any approved contractor list. When I see him around town, we wave to each other like old friends who survived a battle together. The last I heard, Patricia was working at a car dealership in Temp, far from the HOA world where she once wielded so much power. Richard and Karen both moved out of state, probably hoping to escape the shame of their convictions. The new board has been doing a good job. Michael Porter is fair and transparent, always willing to listen to homeowners' concerns. Susan Reeves watches the finances like a hawk, making sure every dollar is accounted for. The community pool got renovated, the landscaping looks great, and nobody is being forced to use contractors they don't trust. Sometimes, I think about how close I came to just giving in that day when Patricia showed up with her packet of rules. It would have been easier to comply, to avoid the conflict, to just use one of her approved contractors even if it cost more. But easy is not always right, and compliance in the face of corruption just enables more corruption. Standing up to the HOA was one of the hardest things I have done. It cost me time, energy, and stress. There were nights I lay awake worrying about legal threats and fines. There were moments I doubted whether it was worth the fight. But looking back now, knowing that we stopped a corrupt scheme and protected other homeowners from being exploited, I would do it all over again in a heartbeat. The Meadowbrook community is proof that homeowners can fight back against HOA overreach and win. You just need to know your rights, document everything, and be willing to stand your ground when someone tries to force you into something that has no legal basis. Patricia Henderson tried to force me to use approved contractors that had no legal basis in our governing documents. She thought her position gave her unlimited authority, and she thought homeowners would be too intimidated or apathetic to challenge her. She was wrong on both counts. My air conditioner still hums along, cooling my house with efficiency and reliability. Dave Martinez did excellent work, just like I knew he would. And every time I feel that cool air on a 100-degree Arizona day, I am reminded that standing up for what is right, even when it is hard, even when it is scary, is always worth it in the end. The Meadowbrook HOA still exists because communities need some form of governance. But it exists now as it should have always existed, as a service organization that works for homeowners, not a power structure that exploits them. The board answers to us, not the other way around. And if they ever forget that, well, there are 150 homeowners who showed up to that meeting who will be happy to remind them. That Tuesday morning when Patricia rang my doorbell feels like it happened years ago, even though it has only been about 11 months. So much has changed since then. I have changed too. I am more aware now of how easily authority can be abused, how important it is to question rules that do not make sense, how necessary it is to stand up even when standing up is uncomfortable. Emma is proud of me, though she jokes that she created a monster by encouraging me to fight back. Our friends in the neighborhood call me the HOA Slayer, which makes me laugh. I am not trying to slay HOAs. I am just trying to make sure they operate legally and fairly. The contractors who were paying kickbacks learned a lesson too. Most of them cooperated with the investigation, and none of them were charged with crimes. They were considered victims of the scheme, not perpetrators. But several of them told me afterward that they would never pay an HOA board again, no matter how much business was at stake. The whole situation opened up a larger conversation in Arizona about HOA oversight and regulation. State legislators introduced bills to increase transparency requirements and make it easier for homeowners to challenge board decisions. Some of those bills passed, creating new protections that will benefit communities across the state. None of that would have happened if I had just complied with Patricia's illegal contractor policy. None of it would have happened if the 32 homeowners had not shown up to that coffee shop meeting. None of it would have happened if we had been too afraid or too tired to fight back. Change requires action. Justice requires effort. And sometimes, the most important battles are fought not in grand courtrooms or legislative chambers, but in suburban neighborhoods over issues like air conditioning units and contractor lists. Patricia Henderson probably still thinks she was in the right. People like her usually do. They convince themselves that the rules do not apply to them, that their intentions justify their actions, that anyone who challenges them is just a troublemaker. But intentions do not matter when your actions break the law. And causing trouble for corrupt officials is not troublemaking. It is citizenship. I hope other homeowners facing similar situations read about what happened in Meadowbrook and feel empowered to stand up for their rights. I hope they understand that HOA boards are not kings and queens, that governing documents have limits, and that homeowners have legal protections against overreach and abuse. Most of all, I hope they understand that you do not have to be a lawyer or an activist or someone special to make a difference. You just have to be willing to say no when someone tries to force you into something that has no legal basis. You just have to be willing to ask questions, demand answers, and refuse to back down when you know you are right. That is what I did, and that is what changed everything. My name is Gregory Thompson. I live in Meadowbrook, Scottsdale, Arizona. I hired my own contractor to replace my air conditioning unit, and I helped take down a corrupt HOA board. And I would do it all over again.